Allora, buongiorno a tutti e benvenuti. Oggi qui è una giornata piovosa sul modello londinese più che romano. Diamo il benvenuto ai nostri colleghi che sono collegati e soprattutto ai nostri relatori. In particolare consentitemi di ringraziare il collega Giuseppe Gaglione che è presente in sede, mentre invece molti di noi siamo collegati da remoto. Lo ringrazio perché ha fortemente contribuito all'organizzazione di questo evento formativo facendo parte della nostra Commissione di diritto europeo e di diritto internazionale. Saluto anche la collega, anche lei che fa parte della commissione, la collega Sonia Marchiafava, che anche lei è presente in aula avvocati. E poi li presenteranno loro, ma intanto mi sembra giusto salutare i nostri ospiti che sono per lo più collegati da Londra, credo, quindi Takis Tridimas, Michael Bowell, Fabrizio Di Benedetto, Kio William, Martin Kresnam, Alfonso Montaldo e Anna Drozd. Quindi li saluto tutti, li ringrazio per aver accolto il nostro invito e oggi il tema è di assoluta attualità e mi fa piacere che partecipi anche la Camera di Commercio, quindi il CC Italia con l'amico Fabrizio Di Benedetto, perché potrà darci anche delle risvolti pratici applicativi rispetto alle questioni tecniche che saranno affrontate come è giusto che sia dai giuristi. Quindi grazie davvero, vi auguro buon lavoro e io resterò ad ascoltare qui collegato. Grazie.
Grazie Presidente, a nome di tutta la Commissione di diritto europeo internazionale e del gruppo UK che ha lavorato su questo progetto, grazie anche a titolo personale per la collaborazione costante che lei offre per l'organizzazione di questi seminari che seguono la scia dell'approvazione del protocollo avvenuto a luglio scorso e compromessa che ci facemmo all'epoca di mettere nero su bianco e voce a quelli che erano appunto gli sviluppi, a quelli che sarebbero stati gli sviluppi del protocollo sul campo italiano e UK. Stiamo andando benissimo, con la collega Sofia Marchiafava, anche lei facente parte della Commissione di diritto europeo internazionale, abbiamo organizzato, devo dire che la parte tecnica giuridica è stata tutta delegata a Sofia che ha competenza in questo settore dei servizi e piattaforme digitali in Europa e UK e sui profili giuridici, una materia molto interessante e di attualità per quanto riguarda il settore di cui andiamo a occuparci oggi. Spendo pochi minuti per riassumere quelle che sono state le nostre idee formalizzate grazie al supporto del Presidente della Commissione di diritto europeo internazionale, in particolare del gruppo UK, che ringrazio tutto, anche a nome di Sofia qui presente, per lo sviluppo di queste tematiche che hanno riguardato sia l'esecuzione di provvedimenti stranieri, riguardano oggi i servizi digitali, copriremo i settori delle successioni cross border, della materia fiscale, della internazionalizzazione delle imprese, veramente interessanti, sono tutte problematiche legate al cross border Italia-UK in un contesto giuridico post-Brexit con tutte le problematiche annesse e connesse. Ringrazio la Law Society, che oggi è qui rappresentata dall'advisor delle EU Policy Anna Drozd, che ci onora della presenza. Anna lavora presso il UK Law Society, il gruppo delle Law Society a Bruxelles, e rappresenta la nostra collaborazione con la Law Society fattiva e veramente a cui l'Ordine di Roma, il Presidente Galletti e tutti noi teniamo molto, così come quella con la Camera di Commercio Internazionale, di supporto sin dal primo dei nostri eventi, oggi rappresentata dal relatore da Fabrizio Di Benedetto, che ringrazio anche per la sua presenza, così come ringrazio tutti i relatori per la loro partecipazione odierna. Molti di loro sono in Inghilterra, quindi sono collegati da remoto, e adesso ovviamente il mio ruolo istituzionale di presentazione di questo webinar odierno, cioè sui servizi e piattaforme digitali in Europa e UK, a termine. Lascio la parola alla collega Sofia Marchiafava, esperta di settore, che introdurrà e modererà in questa sede questo webinar. Ti ringrazio molto, Sofia, personalmente, perché hai veramente lavorato molto su questo webinar, è uscito e riuscirà benissimo.
Grazie Giuseppe. Buon pomeriggio. Good afternoon and welcome to our webinar, everyone. Prima di iniziare vorrei fare qualche ringraziamento, anch'io associarmi ai ringraziamenti, e ringrazio il Presidente Antonino Galletti e la Commissione Europea di Diritto Internazionale ed Europeo, il gruppo in particolare di lavoro UK e il collega Giuseppe Gaglione, che appunto coordina e supporta la nostra attività. Ringrazio l'ICC Italia, in particolare vorrei ringraziare la professoressa Maria Beatrice Deli e la sua assistente Monica Salvatore per la preziosa collaborazione, e ringrazio la Law Society of England and Wales, in particolare la relatrice Anna Drozd, che ha accettato l'invito e ha dato quindi una nuova attuazione all'importante protocollo che è stato sottoscritto a luglio del 2021. Ora vorrei ringraziare anche i colleghi da remoto e un sentito ringraziamento ai nostri relatori. Thank you to you all guest speakers for joining us today. We really appreciate it. And before introducing before giving you the floor, I will just spend 2 words to introduce this important topic, that is digital services and platforms online. We are confronting, in all over the world, with a complex and dynamic digital ecosystem, the result of the last 20 years of significant technological and digital transformation. This innovation takes advantages, but also disadvantages and negative effects. Therefore, these changes leads to a new vision and a new legislation. This happened in EU, and as we will know, and as you will see, in UK. In EU, in December 2020, the European Commission published 2 proposals for regulation. The Digital Service Act, DSA, amending Directive 2031, number 31, sets out several duties and obligations for intermediaries concerning any type of illegal information. And the second proposal is the Digital Markets Act, DMA, that aims to make the digital sector fairer and more competitive, defines clear rules for large online platforms. In the UK, we are also confronted with new legislation as a result of this digital and technological innovation. The government, just a few days ago, March 17, published the Online Safety Bill. About this new legislation and the EU and UK approach is in regulating digital services and platforms, we will discuss with our distinguished, outstanding panel. So I will move to the first speaker, that is Professor Takis Tridimas, Professor in European Law and co-director of the Center of European Law at the Dickson Poon School of Law, King's College, London, professor at Pennsylvania State University, USA. He's a barrister at Matrix Chambers, authors of articles and books in EU law. Thank you, Professor Tridimas, for joining us today. The floor is yours. Sorry, the title of your presentation is The Digital Services Act, Fit for Purpose.
Thank you very much. My great thanks to the organizers and my great thanks in particular to Sofia Machiafava. I'm very grateful for the invitation and it is an honor to take part. I hope my connection is in order. From my end, it plays up a bit. So if I'm not audible, please interrupt me and I will do my best to try and correct. Allow me, if I may, to share with you a set of PowerPoint presentations. Sorry, one second. That should now be. I thought what I would do is provide an overview of the Digital Services Act. Let me first say one word about where we are. This is a proposal for an EU regulation to be adopted by the Council and the Parliament. The proposal was made by the European Commission back in 2020. And it will bring about a fundamental change in the rules which govern the digital economy in the European Union. It is accompanied by a system measure, as it were, the digital, and the two measures, the two proposals are as a package. Now, they are based on Article 14 of the Treaty on the Functioning of the European Union, which enables the Union to harmonize national law. The state of play at the moment is as follows. The Council presented its negotiating in 2020. Parliament made of amendments, a number of towards the end of January, and a number of so-called trials have been
Sorry, Professor Tridimas, we have a problem of connection. Sometimes we don't...
The establishment of the internal market, digital services, to can you hear me now?
Can you speak now, or I can...
Can I? Yes, certainly. Can you hear me now?
Yes, now I can hear you perfectly. Thank you.
Can you hear me now?
Yes.
Yes. My apologies for this. So the objectives of the Act are to provide for a safe online environment, protect fundamental, and ensure transparency and accountability. And the Act, I think, is a very important piece of legislation. It is a major piece of legislation for the following reasons. First of all, it is a transversal measure. It affects essentially all sectors of the economy. Secondly, it provides for an extensive governance regime which go beyond simply prohibiting illegal activities online. I think it is correct to say that it has high compliance costs for the industry. It gives rise to many issues of interpretation, and at a more abstract level, I think it projects a certain conception of democracy, if you wish, one which elevates tech giants into gatekeepers. It also fuses public and private law. This is a regulatory measure, but it makes inroads into contractual terms. And I think what is quite interesting is that it is very, very detailed. It is part of a new generation of EU measures, although they are primary legislation, they go into a very high level of detail, indicating, if you wish, a level of mistrust towards the member states or towards the Commission, who could be responsible for delegated legislation. So a very brief outline of the Act. It introduces a horizontal framework for all categories of content, services, products, and activities of intermediary services. Intermediary services include essentially all online platforms which transmit content or which host content. And it applies to all intermediary services provided that the recipients of those services are established in the European Union, irrespective of the place where the provider is established. So essentially, it tries to balance different fundamental rights. On the one hand, we have the right to conduct business, the right to property, contractual freedom, and on the other hand, we have a host of countervailing rights, freedom of expression, safety, the rights of children, the rights of consumers, the protection of intellectual property, and so on and so forth. So let me very, very briefly pick upon some of the contents of the Act. First of all, liability. The proposal continues existing EU legislation which limits the liability of online intermediaries. They are essentially not responsible for the information which they store unless they have actual knowledge of illegal activity or they are aware of facts that illegal activity is apparent or fail to act when they acquire such knowledge. Also, there is no general obligation on the part of intermediaries to monitor or engage in active fact-finding with a view to identify the content or monitor the behavior of natural persons. Nonetheless, there are provisions which require them to act against illegal content. There are specific provisions on voluntary investigations, and the European Parliament in its amendments has in fact strengthened those obligations. I think what is perhaps more interesting is the host of due diligence requirements that the proposed Act imposes on providers of intermediary services, and I'm simply going to outline them and focus on a couple of them. They must explain in the terms and conditions any restrictions that they may impose on the use of these services. They are subject to very extensive transparency reporting obligations. These transparency obligations are tiered. They become more onerous depending on the size of the online platform. They must put in hosting services, that is, must put in place mechanisms to allow third parties to notify the presence of contact that may be illegal, and they must provide reasons where they decide to remove or disable access to content. The difficulty, of course, here is, on the one hand, to protect freedom of expression, to facilitate the provision of and the transmission of information via online platforms on the one hand, but on the other hand, to limit and take effective steps to prohibit illegal content. Now, online platforms, apart from those which qualify as micro or small enterprises, have the obligation to provide for an internal complaint handling system. So when they take down information, they must enable the provider of the information to complain and have and be heard effectively. They have the obligation to engage in out-of-court dispute settlement. These provisions I find difficult. They are somewhat confusing because they provide for several out-of-court dispute settlement mechanisms, and it is not clear what the relationship among them is. They also have further obligations to inform authorities, provide very extensive reporting and transparency obligations, including the obligation to have compliance and so on and so forth. Okay, I'm not going to take you through in detail through those. What I would like to focus perhaps are a couple of changes made by the European Parliament to the Commission proposal. One of these changes relates to the so-called dark patterns. A dark pattern is a technique, essentially, which tries to manipulate the ability of the consumer to make a free and informed decision or choice. And the European Parliament's amendment tries to strengthen the ability of the regulatory framework to deal with such manipulative practices. This is included in Article 13A, which is an addition made by the European Parliament. And as you can see there, providers of intermediary services may not use the structure, function, or manner of operation of the interface to distort or impair the ability of the recipients of services to make a free, autonomous, and informed decision. In particular, they may not give more visual prominence to any of the consent options when asking the recipient to make a decision. They may not ask or urge the recipient to change a setting or a configuration after the recipient has already made a choice, and so on and so forth. So a lot of very detailed obligations there. There are interesting provisions on the so-called traceability of business users, also referred to as Know Your a professional customer requirement. And the idea is that even though online platforms are not liable for the content of the service, they have a best efforts obligation to identify and prevent the dissemination by traders that use the service of any services which do not comply with union or national law. Now, these are not necessarily easy to implement in practice, and one would expect that they give rise to a number of problems. There are many other provisions on the protection of minors, but the key point is that the DSA seeks to introduce a new governance regime. It elevates platforms to gatekeepers, and I think it is a major piece of legislation that essentially defines public space. In some respects, it equates private parties to public authorities. It takes the view that they are gatekeepers, and they are subjected to extensive due process and transparency requirements similar to those that apply to public agencies. Whether the Act draws the right balance between the conflicting interests, I think, is an open question. It follows what I would call the measured capitalism paradigm. It is fairly paternalistic in its approach, and I think that from the practical point of view, the devil is on the detail. One needs to go through the specific provisions to see how they operate in practice. We will, of course, have to wait and see how much of the text as it currently stands survives discussions and scrutiny in the Council of Ministers. Thank you very much for listening.
Thank you very much, Professor Tridimas, for your brilliant and excellent presentation and overview of the DSA and its most important provisions. Now, we will move to the second speaker, that is Michael Bywell, partnered at Housefield, London. Michael is a senior commercial litigation lawyer best known for his work on complex litigation and arbitration matters, particularly in the technology area. The title of his presentation is UK Online Safety Bill, Key Points and How it Differs from the EU Digital Service Act. So we will see what is the regulation in UK, what is the approach to these issues concerning the digital ecosystem. Please, Michael, take the floor.
Well, thank you very much, Sophia, and just checking that you can hear me okay. I'll assume that you can, but please do say if there's any issues, or buonasera, I should have said first up, and thank you for this very kind invitation to participate in today's event. As Takis just said, it's very much an honour for me to be involved in this. So I'm going to talk about the online safety bill in the UK. This, as I think Sophia has already said, was tabled in the UK Parliament on the 17th of March, so quite recently, although it's been worked on for quite some time before that. What I'm going to do today is to summarise the key features of that bill and then highlight some differences between it and the Digital Services Act. I haven't got time to go through all of them, but I will try and highlight those which I think are quite interesting. The Online Safety Bill targets and imposes duties in relation to both illegal content and legal but harmful content. and I'll come back to that in a moment, and that is a difference. The second part of that is a difference between the Online Safety Bill and the Digital Services Act. So you've got illegal content on the one hand, or one category, and legal but harmful content in another category. It has been introduced, as Sophie's already said, to account for the very significant societal and technological changes that have taken place over the past 20 years. And also, according to the UK government, the failure by online platforms to self-regulate in an effective manner during that time. And like the Digital Services Act, the Online Safety Bill aims to create a safer and trusted online environment for users. One statistic that caught my eye when I was preparing this talk, and this comes from one of the consultation papers back in a couple of years ago, in fact, and it refers to the 2020 lockdowns, the COVID lockdowns. And the two statistics are these. The first is that during that period, 47% of children saw unwanted content online, and no fewer than 8.8 million attempts were made, but blocked, I'm pleased to say, to access child sex abuse material in just 1 month. So plainly, this is all very concerning and an area that the UK government is determined to address. Indeed, they want to try and pass the bill, or get the bill passed this year, if at all possible. Now, it's a complex piece of legislation, and it's still very much at the framework stage for reasons that I'll come on to now. It's a game changer, no question about that, for UK internet users and their providers. For providers, the platforms and search services, that is, it means a huge amount of risk management and compliance work, together with the risk of facing criminal sanctions and financial penalties for non-compliance, which I'll come on to. And for users, as I say, it promises better protection. It runs to more than 200 pages already, and that's before any codes of practice or guidance have been published by the regulator Ofcom, or indeed before any secondary legislation in the form of regulations to designate what type of legal but harmful content will be caught by the legislation have been published. That said, the types of harmful content likely to be included and designated are things like cyberbullying, content that encourages self-harm, eating disorders, and other types of harm where physical or psychological damage is suffered. And this can relate to the nature of the content itself, or the way in which the content is disseminated. For example, where someone is sent the same email over and over again. Other activities and deliverables to follow include Ofcom guidance to assist providers with their compliance duties, and that guidance will only be ready once Ofcom itself, the regulator, has performed its own risk assessment of harm to individuals and developed risk profiles for the different types of regulated services. So I'm afraid, I think at the moment, the conclusion is that it's a very worthwhile piece of legislation, but it's very much at the framework only stage, to my mind. And I think it's quite difficult at this point for the platforms and search engines to start their compliance planning in any detail. I've already talked about legal but harmful content, but what is meant by illegal content? I think this is more straightforward, and the bill itself does specify what the illegal content is, and I won't read them all out, but it's things like terrorist content, content relating to child sex exploitation, threats to kill, public order offences such as harassment and stalking and so forth, proceeds of crime and fraud, so that type of thing. What it doesn't include, however, are offences relating to IP or intellectual property infringement, which is expressly excluded from that list. So who does the bill apply to? Well, it applies to user-to-user services. So this is where users are generating and uploading and sharing content. It applies to search services, And it also applies to, and this is a recent change, services on which provider pornography appears. So this is not user-to-user generated. This is comes from the provider. And importantly, where there are links between those services and UK users. For example, where there are a number of, or significant number of UK users involved. The providers will be divided into 3 categories, and broadly speaking, category 1 will be the larger platforms, category 2A will be the search services, and category 2B will be the other online platforms. But even then, Ofcom, the regulator, needs to set the thresholds and parameters for those categories once the bill has passed into legislation, so that hasn't happened yet. There are some exemptions for things like multimedia messaging, emojis, GIFs, one-to-one oral communications where there's speech or sound only involved, among others. In terms of duties, the duties and steps that providers are required to take are many, but they do vary depending on what type of provider they are and whether the user is an adult or a child. And there are probably too many to go through right now, but broadly speaking, these tasks include preparing risk assessments, having clear terms of service, publishing annual transparency reports, restricting access to certain content, for example, access by children to pornography, preventing users coming across what they've called priority illegal content, which is child sex exploitation content and terrorist content, and having reporting systems for users to report content which could be illegal or legal but harmful, and also complaint procedures. One area that has been quite controversial, I think Taki's touched on this as well, is freedom of expression and the requirement that providers have regard to that when performing their duties. Now, these concerns don't relate to the notion of freedom of expression, of course, but rather the challenges for providers when deciding what content to remove or take down. There are also duties in relation to user controls, particularly for adults, and also fraudulent paid for ads. And there's an obligation on the larger platforms to provide tools to enable adults to filter out unverified users and control the content they encounter. And in the case of fraudulent advertisements, to have systems and processes in place to prevent users from encountering fraudulent advertisements. And the search services have the same obligation. I'm conscious of time, so I'm not going to say too much about Ofcom. They do have a whole raft of duties and actually a very, very big job to do in relation to this legislation. They have a general duty to safeguard citizens, and as I've mentioned already, it's up to them to produce codes of practice, to research the services categories, to advise the government on how category 1, 2A and 2B should work, and also to prepare risk assessments and risk profiles and publish those to help the platforms with their compliance. They also have Ofcom also has a broad range of enforcement powers to issue information notices as part of investigations, to conduct interviews, to enter and inspect, and interestingly as well, to call upon experts, which the platforms have to pay for, to conduct reports where Ofcom deems it necessary because they think that a platform has failed or might fail in the future. So quite a subjective judgment for them to take there. Financial penalties, the fines can go up to 10% of worldwide turnover or £18 million, whichever is the higher. Ofcom can issue notices requiring people to remedy a contravention and also impose a fine, which I've just mentioned. I also wanted to just call out, I think, quite a clear statement in the bill from the UK government, and that comes in the form of criminal sanctions or criminal criminal sanctions or potentially criminal sanctions for both corporate officers and senior managers in organisations. So a corporate officer, for example, could be found guilty where he or she knows that there is non-compliance, but nonetheless really goes along with it and doesn't say anything about it and allows it to happen, just to put it simply. And similarly with senior managers, if they are appointed as part of an investigation by the regulator and are dealing with an information notice, then if there's anything wrong in the information notice in terms of inaccurate or misleading information or non-compliance, then the senior manager can also be criminally liable, provided that the organisation is also found liable. So attempting very briefly to compare the bill and the Digital Services Act, they are, as we've already discovered and already talked about, variations on the same theme, which is all about trying to achieve a safer and trusted online environment by requiring transparency and accountability and regulatory oversight. But I think one area where I think there's a clear difference, and as far as I can tell, nothing is said expressly about this in the Digital Services Act, is this notion of legal but harmful content. And from my reading of some of the EU papers, I see quite early on in December 2020, the Commission took the view that they would stay away from legal but harmful content and focus just on illegality, if you like, for fear of running into issues around freedom of expression. I won't read you out the section from that consultation, but that seems to be a decision that was taken fairly early on. And by contrast, of course, the online services, the online safety bill does provide for legal but harmful content, as we've already seen. So overall, it feels to me like the UK legislation potentially provides a bit more protection for users because of this category of legal but harmful content. But I think the reality will only play out once the legislation is passed and once the Digital Services Act is passed as well, and we see how some of these issues are tackled in practice. Fines and criminal sanctions, I've touched on the UK fine regime already. The EU cap is 6%. That compares to 10% global turnover in the UK. But what the EU does have that the UK doesn't is an additional fine, or the potential for an additional fine, for non-compliance with information requests or where misleading information is provided. Online advertising is another one that I've called out for brief mention, and I think probably the EU is ahead of the UK here, at least for now, and that the EU, as I'm sure will be explained in other presentations this afternoon, bans certain advertisements that target children and other advertisements based on ethnicity, political views, and so forth, and also requires the very large online platforms to maintain a database of verified ads. So the UK isn't quite there yet. They've done some work in relation to fraudulent advertisements, and more is promised through a new consultation, but that is to follow. So finally, it would be remiss of me as a litigator not to mention the prospect of civil claims arising out of both sets of legislation. The Online Safety Bill at clause 19.4 refers to the right to bring a claim by users, so the right for users to bring a claim for breach of contract in a wrongful takedown situation, so where content is removed when it shouldn't have been under the terms of service between the parties. And one can see scope for making claims the other way around, where content should have been taken down but wasn't. And also one can see the common law having a role to play here, which could lead to a broader set of claims being made. Article 43A, which was a recent amendment to the Digital Services Act, also talks about compensation, and I won't sort of read that out, but that I think again is a clear signal that it is contemplated in both the EU and the UK that users will have the ability to bring civil claims against platforms for breach of contract, for breach of the legislation, or in the UK for breach of common law. Whether there will be class actions, representative actions, that remains to be seen, as there have been in the GDPR world. One can see, for example, the potential where, say, a group of 50 or 100,000 users all suffer in the UK the same fraudulent online scam, if I can put it that way. They all suffer similar loss or the same loss. One can see the beginnings there of a group or class action. Similarly, claims for perhaps by individuals or again at a group level for distress as a result of providers failing to block or remove illegal or legal but harmful content. So I think I've run over by 1 minute according to my timekeeper, but thank you, and that is the end of my presentation.
For the excellent overview of the Online Safety Bill and the comparison with the Digital Services Act. I will go on, and here I will introduce Mr. Di Benedetto, Fabrizio Di Benedetto, co-chair of the Commission ICC, the Competition Commission, Commissione Concorrenza ICC Italia. The title of his presentation is A European Perspective on Platforms, the Digital Markets Act. So we will see the Digital Markets Act and the EU approach in regulating platforms, in particular the large platforms. Please, Mr. Di Benedetto, the floor is yours.
Thank you. Thank you, Sophia. I hope you can hear me well. Okay. Just a few words in Italian and then I turn to English. Intanto buonasera a tutti, grazie all'Ordine degli Avvocati di Roma per l'invito. Il Presidente Galletti dice ci darà Di Benedetto gli aspetti pratici. Temo che, visto che si tratta di normativa ancora che deve entrare in vigore, gli aspetti pratici non riuscirò a darli tutti, ne cercherò però di darne alcuni. Thank you all. Thank also to the speakers. It is essentially an outstanding panel, but not for my presence. I will try to give you a very brief overview of the Digital Markets Act, which is, let me say, a complementary proposal to the DSA that Professor Tridimas has explained before. Also, this proposal is not in force already, but fortunately, the European legislators, the Council and the Parliament have reached a few days ago a political agreements on the political terms of DMA, the Digital Markets Act. Then I have prepared my slides using basically the proposal of the Commission, some amendments of the Parliament, and the public news that we have after the political agreement reached last week. I think it is essential to start with the characteristic of digital markets in order to better understand how the Digital Markets Act will try to give an answer to the concerns. Digital markets are basically characterized by extreme scale economies. Okay, marginal costs are basically zero in order to add one business user or end user. Just think about Facebook. Facebook basically does not have cost to add a new business user or especially a new end user, for example, a consumer. Yes, there are also strong network effects, stronger network effects than in the past, because in the past we had two-sided markets and no more. now we have multi-sided markets. For example, social networking or Google as search engine. But I think that the main issue here, and the main concern of the Commission that forced, let me say, the Commission to adopt such a proposal is the fact that in digital markets, there is a very strong degree of dependence of business users and end users on those kind of platforms. Just think about small retailers that need to have a contract with, for example, Amazon to sell online. So in competition terms, I am an in-house competition counsel. Let me say, it's a sort of quasi-dominant position of those gatekeepers, and usually those gatekeepers are unavoidable trading partners. You must have a contract with them. Who are the gatekeeper according to the Digital Markets Act? Well, the feature of gatekeeper are basically those three. You are a gatekeeper if you offer core platform services. That means that you have a strong economic position and especially a strong intermediation position. So you are in the position to intermediate, to link very big numbers of business users with very big numbers of end users, for example, consumers or end user in general. I tried, with this slide, I tried to figure out what will be, maybe, but I may be wrong, but I think that those big techs mentioned here will be designated by the Commission as gatekeepers. It is not a new thing to say that Google is the dominant player in online search engine, or, for example, that in cloud computing, Google again or Amazon have very strong positions. So I think that basically this is a piece of legislation. When the Commission wrote this piece of legislation, the Commission had in mind basically what we call GAFA or big techs, if you prefer. Why a competition policy tool? We can say that the DMA is basically a competition policy tool, although it is based on Article 114 of the Treaty on the Functioning, so the article on internal market harmonization. Why having a competition policy tool, an ex-ante regulation, a pro-competitive ex-ante regulation, if we have already the antitrust enforcement? Basically, the Commission considered that antitrust enforcement has some kind of limitation. For example, as you all know, antitrust enforcement is an ex post intervention, and mainly, I think, unilateral conduct of companies can be sanctioned by antitrust law, at least in Europe, only in case of an abuse of dominance. And I have said before that these kind of companies, the gatekeepers according to the DMA, can be considered unavoidable trading partner, but it is not necessary. That doesn't mean that an unavoidable trading partner is also a dominant company according to Article 102 of the treaty. So the reason behind the adoption of DMA are basically these three: dependencies of business user on those platforms, unfair practices that the Commission considered to have seen in the past, and a lack of contestability of those markets. They have, let me say, an entrenched position. It is not easy to compete with gatekeepers. The consequences of this kind of reasons are basically typical antitrust or competition consequences. So the Commission wishes to avoid inefficient outcomes due to the market power, which is not necessarily a dominant position, of those gatekeepers. But who are gatekeepers. Okay, I have tried to figure out that Google, Microsoft, Facebook, and so on will be designated as a gatekeeper. But if we consider the threshold that the Commission proposal and also the amendments of Parliament and the Council have agreed on this kind of tool to individuate gatekeepers, so the Commission have, as you can see from the slide, has decided to consider basically two kinds of threshold. The first threshold is based on turnover. It is very similar to other thresholds, for example, merger regulation thresholds. But the second one, I think, is more interesting because it's first of all, these are cumulative thresholds. The second one is based on active users in the union. So it will be a mix. Just to individuate a gatekeeper, we will have to consider both turnover, as in traditional word, but also these second threshold based on active users. The European Commission can also designate a company as a gatekeeper, even though the company does not meet the thresholds. This will be, as Professor Tridima said before, the devil is in the details, and this is a detail. And maybe the devil can be here also, because the Commission will have the possibility to conduct a market investigation and then to designate companies as the gatekeeper, although they do not respect the threshold that you can see here. After the entry into force of the DMA, what will be, let me say, the compliance activities of gatekeepers? And now I turn to the practical side of my intervention. Gatekeepers, first of all, must verify themselves if they meet the threshold, and then notify to the Commission the fact that they consider to be within the scope of the DMA. Then the European Commission will designate officially the undertaking as a gatekeeper, and this status of gatekeeper can be reviewed in the next years. Once you have been designated as a gatekeeper, you will have to respect some obligation that tries to give an answer to the concern that we have seen at the beginning of my presentation. So the concern of dependencies, unfair practices in the digital markets. We have two sets of obligation. The first one is a blacklist. It is Article 5 of the DMA. And the second one is a gray list of obligation. Let me say, this will be not easy to handle, especially in terms of private enforcement, because it is not clear, it is still not clear, how national courts could apply Article 6, because there is a very strange definition. The Article 5 blacklist is defined as hard law, while self-executing provisions, but usually regulation under EU law have self-executing provisions, but Article 6 consider provision, obligation that may be further specified by the Commission. It is not clear. And this is, let me say, a second detail that hides maybe the devil. Article 5 basically aims to reduce data advantage of gatekeepers. As you know, gatekeepers usually compete also with their business user. Consider, for example, Amazon. Amazon is not only the wholesale seller, but it is also a competitor of retailers that uses Amazon to sell their products and services. And Amazon has the possibility to acquire more data on products and services sold on the platform, And this kind of data acquisition can give Amazon, for example, an advantage against its small competitors. Just to give you an example of an obligation under Article 5. Our obligation under Article 6 are, notwithstanding the interpretative problem that I have mentioned before, in any case, are very, very interesting. Also in this case, the point of the starting point is just to try to reduce advantages of platforms, especially in competition with other business users that use the platform to sell their products and services. And so, for example, you can see here that DMA is trying to widen data portability, which, as you know, today is regulated by the GDPR for consumers, for natural persons, obviously, while the DMA is trying to extend data portability also to companies. And that will be a very important, I think, there will be a major impact of Article 6 once we have, or at least once I will have understood the effects of Article 6, which are not so clear. After the designation as a gatekeeper, the company must notify to the Commission how it intends to implement Article 5 and Article 6. If the Commission is not satisfied, there will be a sort of dialogue between the Commission and the company to try to fine-tune the implementation of obligation under Article 5 and 6 by the gatekeepers. And if the gatekeeper does not comply with Article 5 and 6, the Commission may issue non-compliance decision and impose fines up to 10% of the total turnover of the gatekeeper, which is very similar to the threshold of sanctions under antitrust law in Europe, or up to 20% of the turnover in case of systematic non-compliance. What is systematic non-compliance? Systematic non-compliance under the DMA should be when a gatekeeper has infringed at least 3 times the DMA. So if the Commission has issued 3 different non-compliance decisions, the third will be considered a systematic non-compliance. So it will be possible to be sanctioned up to 10% with the first decision, up to 10% with the second, but up to 20% with the third decision. Obviously, and it's like antitrust regime, before issuing a compliance decision, the Commission can suggest a measure or accept commitments offered by the gatekeeper. This is very, very similar to Regulation 1/2003. Last part, after the amendments of the Parliament, it is more clear, in my opinion, the role that national courts will have in the private enforcement of the DMA. And I think that, again, in this case, Regulation 1/2003 will be a point of reference, an important, in my opinion, point of reference to better clarify such a cooperation between the Commission and judges, national judges, on DMA issues. And after the political agreement of a few days ago, member states should be able also to allow national competition authorities to investigate according to the DMA, and then to file a complaint to the European Commission that will remain the only public enforcer of the DMA, according to the most recent text. And this is all from me. Thank you.
Mr. Di Benedetto, for your perfect, clear presentation of the DMA. Now we'll pass and move on to Kyo William, that is Senior Associate at Housefield. Kyo specializes in competition litigation, data protection, claims and commercial disputes. We will see with him, the presentation is UK pro-competition regime for digital markets, key differences. So it's perfectly his presentation after Di Benedetto one, because he will make the key differences between the Digital Markets Act and the regulation in UK. Please, Kyo, the floor is yours.
Thank you, Sevilla, and thank you for the invitation to speak. It's a great pleasure to be speaking on this very interesting topic. So, as introduced, I'm going to speak to the proposals recently introduced by the UK government for what it calls a new pro-competition regime for digital markets. And so my aim in this short slot is to highlight 5 examples of how the UK's proposed regime differs from the Digital Markets Act proposals that Fabrizio has just talked through. So by way of very quick overview of the proposed UK regime, the UK government's proposals essentially seek the same goal as the EU Digital Markets Act. Essentially, they both aim to create a new ex-ante regime to tackle the specific challenges to competition that are posed by fast-moving digital markets. To administer this new regime in the UK, a new specialist regulator will be established, and that will be called the Digital Markets Unit. However, for a few months now, the regime has been put on ice as we wait for the necessary UK legislation to be passed to confirm the final form of the new regime and when the regime will be brought into effect. So it'll be interesting to see now, given that the timeline for the implementation of the Digital Markets Act at the EU level is clear, whether we're given some indication from the UK Parliament of when the new UK regime will be introduced. So at its most basic, under the present UK proposals, the UK Digital Markets Unit will have 2 parallel goals. The first, which is under what I refer to as Pillar 1, is the goal is to tackle certain economic harms that result from the exercise of market power wielded by certain digital firms. And to do this, the Digital Markets Unit will create and enforce firm-specific mandatory codes of conduct. Then under Pillar 2, in parallel, the second goal for the Digital Markets Unit is to tackle the sources of that market power. And they will use what they refer to as pro-competitive interventions to do this. So these are 2 parallel goals that the Digital Markets Unit will be seeking to achieve. Thirdly, I've just flagged there the third pillar, which will be administered by the Competition and Markets Authority, is the proposal to implement a new proactive merger regime that is specific to digital firms. So despite the 5 differences that I'll discuss now, I should flag that one of the key ambitions of the UK government is to promote coherence both domestically and internationally. And so it's unsurprising that as these similar proposals take shape, we will see more convergence in approach than perhaps the divergence that we saw a few months ago when the proposals were first introduced. So looking at the first key difference between the UK proposals and the EU Digital Markets Act, I've decided to focus on the way in which the 2 regimes will identify firms that are subject to the new rules. So unlike the DMA, the express goal of the UK regime is to be as targeted as possible towards firms and activity where the risk of harm is greatest. The designation process is not designed to be self-executing in a way that we just heard from Fabrizio, because there are no presumptions, as we have seen in the Digital Markets Act. So my understanding is that the CMA anticipates there'll be about 10 to 15 designated firms with what they refer to as strategic market status. And they will be the usual suspects, as Fabrizio mentioned, the Google, Meta, Facebook, Apple. But it's not clear yet who the other 10 or 11 firms that will be designated are. So in administering this targeted regime, the Digital Markets Unit objective is to positively identify firms with what they identify as substantial and entrenched market power in at least one activity, which we'll see can comprise multiple products and services that provide that firm with a strategic position. So that's the test. And for each of those three words highlighted on the slides, substantial, entrenched, and strategic, that there are certain criteria for identifying these, which are set out in the proposals. So unlike the Digital Markets Act at the EU level, unlike those proposals, there's no presumption of strategic market status that is automatically triggered, for example, by market capitalization figures, revenues, or end user numbers. The designation process instead is far more labor intensive, as it's based on mostly qualitative assessments of market power, similar to those assessments which we've already seen the CMA doing in market studies conducted to date. And I've placed on screen two examples of those digital market studies, one in online platforms and digital advertising that was published in 2020, and one more recently, an interim report published in Studying Mobile Ecosystems, published in 2021. And as you'll see on the screen, the CMA has already identified Google, Facebook, and Apple in a number of respects that they would have strategic market status. So this is in anticipation of the new regime being implemented. The CMA has conducted in-depth analysis and been very transparent about the way that it's conducted that analysis and has identified these three firms so far with strategic market status. Once designated, that label of having strategic market status will last for 5 years. So turning to the second key difference that I've identified is the different ways in which the proposed ex-ante rules will be applied. Like the list of rules that Fabrizio just talked us through under Articles 5 and 6 of the Digital Markets Act, the UK Digital Markets Unit will implement codes of conduct, which will essentially set out the rules and descriptions of how each designated SMS firm is expected to behave. The goal is to influence behaviour, as with the Digital Markets Act, in advance and prevent negative outcomes before they occur. However, unlike the Digital Markets Act, where we have a list of 18 black and grey list rules for firms to adhere to, the codes of conduct will actually be tailored to specific businesses and the specific business models of the SMS firm in question. And these legally binding rules are capable of being changed over time as businesses and technologies develop. The codes of conduct, quite simply, will comprise three parts. At the highest level and most abstract level, we have three objectives, which the Digital Markets Unit will aspire to achieve, and that is to ensure that in each of the relevant areas that they're looking at, they will encourage SMS firms to behave in a way that encourages fair trading, open choices, and trust and transparency. And you'll see on screen the general objectives behind each of those is to prevent exploitative conduct, prevent exclusionary conduct, and promote informed and effective choices by users on these platforms. At the second level, beneath those three objectives, we have principles which will be set out in legislation that are applicable to all the SMS firms again. However, unlike the Digital Markets Act proposals, the Digital Markets Unit in the UK will have the power to develop additional legally binding requirements in relation to these principles, so slightly more flexibility, and it's similar to the approach that we've seen taken in Germany recently under changes to their Competition Act. And lastly, just a quick mention that there's also the opportunity for the Digital Markets Unit to develop and publish guidance, non-legally binding guidance, which again is specific to the firm in question and will apply only to that firm. So turning to the third key difference between the UK proposals and the DMA is what the DMU, the Digital Markets Unit, refers to as pro-competitive interventions. So the difference is the way in which and the availability of interventions will complement the ex-ante rules that the two regimes seek to introduce. So while the UK Digital Markets Unit thinks that codes of conduct are needed to deal with the effects of harms in the relevant markets, the government's view is that alongside these codes of conduct, we will also need some more invasive interventions that will be required to rebalance digital markets that arguably have already tipped. So these are referred to as pro-competitive interventions, and they'll enable the Digital Markets Unit to actually tackle the root causes of SMS firms' entrenched market power at the same time as the codes of conduct. So similar to Article 16 of the DMA that Fabrizio just talked us through, where the Commission will deal with instances of systematic non-compliance by intervening with more onerous behavioural or structural remedies. The key difference here is that the Digital Markets Unit in the UK can introduce these remedies at a much earlier stage. It isn't just in the case of non-compliance or systematic non-compliance. I've included an example on the slide of how a code of conduct might be required to tackle undue self-preferencing. But then, as you can see, a pro-competitive intervention might also be required if that code of conduct alone isn't enough, and functional separation might be the remedy that's required to remove the underlying incentives for self-preferencing in the first place. Moving on to the fourth key difference that I've identified is the Digital Market Unit, well, the UK government's proposal to introduce proactive merger rules to complement the codes of conduct and the pro-competitive interventions. So this is a key difference because there's comparatively little in the Digital Markets Act, the EU proposals, on merger control. And I understand this to be the case because there's no legal basis for the Digital Markets Act to actually alter the EC merger regulation. So unlike the Digital Markets Act proposals, the UK government actually proposes that it should introduce a new pro-competitive merger regime, but it's specific and will only apply to firms with strategic market status. The obvious goal is to address historic under-enforcement against digital mergers and the fact that strategic acquisitions have been part of the business models of a number of tech firms. And these strategic acquisitions have clearly contributed to create market power that has then become entrenched and enabled those firms, in some cases, to leverage unfairly into adjacent markets. So on the screen, I've listed a few of the proposed measures, but the three key ones that I'd like to focus on are, number one, for a new advance notice reporting requirement on SMS firms to inform the C of A of all proposed mergers and acquisitions. So this is similar to the new obligation under Article 12 of the Digital Markets Act for gatekeepers to inform the Commission and national competition authorities of all transactions involving core platform services. So that first one's quite similar. However, the second and third that I'd like to focus on are different, and they highlight a difference between the UK and EU approaches. So the second one is the introduction of a transaction threshold, which triggers the ability for the Competition and Markets Authority to review the concentration under Phase 1. So the idea here is that the transaction value of a deal is actually a better measure of whether the merger activity should be reviewed, as opposed to the previous measurements under the existing regime, which are based on turnover or market share of the target company, which might not be significant at the stage that the review takes place. So the introduction of a transaction value threshold with reference to the price actually being paid by the SMS firm for the smaller tech firm, that's the key point for the regulators to focus on. And this mirrors the approach recently introduced, as I understand it, in Austria and Germany to deal with the unique challenges posed by the acquisition of tech companies. The third key difference that the government proposes is actually lowering the probability threshold at which the CMA can intervene at Phase 2. And it's only following a Phase 2 assessment that the CMA could potentially order remedies or block an acquisition. So the new threshold test will be whether there's a realistic prospect of a substantial lessening of competition. So the substantive test stays the same. What the CMA is looking for is a substantial lessening of competition as a result of the merger or acquisition. But what is changing is the probability or the certainty required in order to intervene. It's being reduced from more likely than not to a realistic prospect of a substantial lessening of competition taking place. So that key change is that the CMA doesn't have to be certain that there will be a substantial lessening of competition, Just if there is a chance of it happening, then the CMA would have the authority to act. And the CMA have recently said that uncertainty shouldn't be used for an excuse for inaction when it comes to merger control and digital companies. So while there are no comparable wholesale changes to the EU merger regime for the reasons I've explained, it does appear that an amendment proposed by the European Parliament has been adopted in the final text of the Digital Markets Unit, which only became clear at the end of last week. And the effect of this amendment is that it links the gatekeeper's obligations to inform the Commission under Article 12 of a proposed transaction or merger. It links that obligation to inform with new guidance, which has been published under Article 22 of the EU merger control rules. And that urges national competition authorities to request that the Commission examines concentrations that otherwise wouldn't have met turnover thresholds at either the EU or national level. So rather than amending the EU merger rules explicitly and directly, there's a bit of a workaround which enables the Commission to require companies to notify in advance, but then it's the national competition authorities that can use that information to refer back to the Commission and say, please, can you look at this concentration or acquisition? And it's hoped that these changes will deal with the killer acquisition problem that relates to mergers that under the previous merger rules may have slipped through the net. So finally, conscious of time, I have a few more seconds. I'll turn quickly to consumer welfare and the prospect of private enforcement under both of the regimes. So there are differences between the EU proposals and the UK proposals, and there's differences as to the scope and potential for private enforcement to take place. Despite references throughout both sets of proposals to consumer welfare, during most of the negotiations and consultations, both ex-ante regimes appear to focus primarily on business users. But for obvious reasons, consumer welfare should be at the heart of these new regimes. And one effective way to do that is to factor in an effective private enforcement regime at the outset. So looking at the Commission's DMA proposals first, back in December 2020, from the outset, they were silent on private actions, but we knew that the regulation would have direct effect. And as Fabrizio mentioned, Article 5 and 6 would be enforceable in national courts. How, we're not sure yet, but in principle, they are enforceable. However, what became clear at the end of last week, just a few days ago, was at the last minute in the negotiations, it would appear that in the final agreed text of the Digital Markets Act, there's now express provision for collective actions from individuals and businesses in national courts. So not just private actions between companies and platforms, this is also collective actions on behalf of consumers, and that's the significant development. By contrast, the UK proposals, it's very unclear whether private enforcement will be a feature, and the UK government has said they'll look at this within 3 to 5 years after the rules being introduced. So on this basis, it looks like there's an interesting risk of asymmetry in the remedies available to claimants under the new regimes. And depending on how the regimes develop, UK business users and consumers might have fewer avenues for redress against big companies following breaches of the new rules. So the UK consumers and businesses may have fewer avenues for redress than their EU counterparts, which is quite an interesting comparison. I'll be very quick and just mention that obviously the influence of private enforcement and its importance is clear where concerns are already being raised about the capacity of the regulators to actually enforce these new regimes. And as the Commissioner Vestager said a few days ago, the proof is in the pudding. It's all about how these regimes, their success will be measured in how effectively they're enforced. And there are questions circulating as to whether the regulators actually have the capacity to hold each of these companies to account. So here there's a clear role for private enforcement to play in holding these firms to account and providing redress and compensation to the victims of conduct which are found to be in breach of the new regimes. I'll stop there, and so we have time to move on to the other speakers.
Thank you very much, Kio, for your excellent presentation. I'll move on to the next speaker, Professor Martin Kretschmer, Professor of Intellectual Property Law, School of Law, and Director of Create Centre at University of Glasgow. author of books and articles. He's involved, among others, in a project about platform regulation. Please, Professor Kretschmer, I leave you the floor.
Well, good afternoon from Scotland. Thanks for the invitation, and it's an honor to be here, but we have got only 30 minutes now for 3 presentations, so I need to rush. I share my screen, and I will use a PDF because of the bandwidth issues, so I will just scroll down a PDF. Okay, so copyright law may seem a special case and perhaps an unusual bedfellow with, terrorism, child pornography, dominant services. I will argue that in some ways copyright law anticipated some of the issues which are now surfacing elsewhere. For 20 years, we had experience of a formal takedown system enforced at scale. And also empirically, copyright law, which may surprise many of you, accounts for most of the content moderation decisions by the firms we are having in scope today. So it's been very useful to listen to the other speakers and to look at these 4 interventions together, which all speak really to a fundamental shift in the regulation of big tech. If you look back to the 1990s, when the current regime of intermediary liability was established, the rules are based, around a liability shield, and famously, the 26 words from the Section 230. It was a US kind of shaped regime, the 26 words that created the internet by offering this liability shield. And following on from that, we had the specific copyright intervention, which for the first time globally introduced a specific notice and takedown regime, which was then, in fact, by Google rolled out globally, regardless whether countries had a safe harbor provision. Google operated the essentially a regime which is based on the DMCA. So the EU broadly followed the US. It has a less specific notice regime, but we still have, the underlying idea that liability only arises if there's knowledge, and if there's knowledge, the service has to act expeditiously, otherwise it will be liable. And in addition, famously, the EU has the prohibition on general monitoring. So the new wave of platform regulation changes this from the ex post obligations upon obtaining knowledge to ex ante obligations, which are more specific for this new category of firms. I call them here strategic platform firms, and the terminology differs between the 4 interventions we looked at today. The gatekeepers in the DMA, the strategic market status firms in the coming UK legislation, which will give powers to the Digital Markets Unit within the CMA. We have the VLOPs, the very large online platforms within the DSA, and we also got this new category of high-risk, high-reach Category 1 services in the Online Safety Bill. And prior to that, we already had in the Copyright and Digital Single Market Directive a new category here for essentially sharing services, online content sharing service providers under Article 17, which lost the liability shield. So if you fall within this category, then you become liable for the content uploaded by users to your service. And therefore you have to obtain a license. So the threshold conditions here are, there are also carve-outs for, smaller companies and startups. So there
very few companies which come within this categorization. It's often called the YouTube law. So in our approach, we stand for in the Create Research Center is to take always an empirical perspective on regulation, which is quite unusual for copyright lawyers. It's quite unusual also for the wider field of online harms. Competition law is much more used to that. I think it's extremely important to understand what we are trying to regulate. So here's an example. That's the first example of the new wave of I assume liability arrangements which put pressure ex ante on services, and that's the Netzdige law from Germany in 2017. It for the first time had these transparency requirements and also a specific time window in which a service had to act. And it allows us for the first time here, because of the reporting requirements, to see how these kind of new duties translate into behavior. And what you can see here for YouTube and Twitter is that the content notified is much greater than the contents taken down. So there are lots of decisions to be made by platforms whether these rules apply or not. So the German law contains a list of criminal offenses. The intellectual property right is not part of that. A specific list of offenses which trigger these new obligations. But then the assessment whether they apply or not falls on platforms. And that's one of the themes I will come back to. Trillimas already pointed to this strange mix between private and public lawmaking here, that we use essentially platforms for public functions. We also see that Facebook did not comply and got a fine. Now, a few more recent content moderation illustrations. These are from The Economist. What we see here on Facebook, that in fact it has started to respond to these new obligations which came through various national laws. But if you look at the bars here, you will see that now Facebook is acting, but it is mostly acting here on flagged by Facebook. So these are algorithmic decision making. So it's not that a user notified under the old liability regime. It's essentially Facebook policing through algorithmic techniques the content which appears on their platform, and then making automatic decisions. Okay, so while we've seen before that there's this big gap between what users notify and how platforms act, increasingly we're moving to a world where essentially this kind of ex ante approach is already applied. And it's mainly applied to support the terms of services of the platforms themselves. And if you look at Twitter here, I think the message I want to convey here is that up to 2019, Twitter did not really respond to demands for removal of tweets. They pushed the liability back to the uploader rather than acting. And the share of those notifications where they actually reacted to legal demands has gone dramatically up. So again, this speaks to that we are in a period of quite dramatic change in behavior by these platforms. The next slide here, this is data I've compiled myself from Google Transparency Reports. Here we can see that Google has removed, either delisted or removed more than 5 billion items since 2012. So these are copyright content removals. And to put that in context, they've got a separate category for content delisting due to EU privacy law. So that's in response to the Google Space case and the right to be forgotten. And here the requests are just above 1 million. Then we have got government requests, which mostly are national security based, and they are 15 to 25,000 per annum. And then we have got the specific removals from Netzdige. There's now this category which is based on a legal intervention, which again shows you how things might move with the new obligations placed in the laws we've just been looking at. Okay, so I need to rush. What I want to summarize here is that from 20 years of copyright takedowns at scale, we know the following things. There's been this massive increase in what's been called robo-notices, essentially automatic enforcement mechanisms, which we now also see in other areas. There's potential over-enforcement and insufficient human review. There's an underuse of counter-notification mechanisms by users. So, if something which is not a copyright infringement but is triggered by Google Content ID is taken down, the incentive to act against that is pretty low. And also, improving takedown is very costly. So there are advantages for larger platforms. And I assume the biggest economic cost of the new family of interventions we have in front of us today will be the costs of content moderators to the platforms. So Facebook employs 35,000 mostly outsourced content moderators. So having a greater range of ex-ante obligations will require enormous investments complementing the technology with the human review. Okay, so now I come to the specifics of the DSA and copyright law. So under the DSA, copyright infringing content is illegal content. So these new due diligence and due process obligations will apply. And for the first time, they will add a level of specificity in the EU, and also some safeguards for users. So this is very welcome. It also exceeds what is available under Article 17 for these particular content sharing services. So the argument which the European Copyright Society, in their opinion, to which I contributed, make is that, in effect, in important respects, the DSA will trump the Copyright Digital Single Market Directive provisions. In the Online Safety Bill, copyright does not feature. As Michael Bywell already indicated, there is a specific carve out for intellectual property rights, so they don't infringement of the intellectual property rights do not trigger this new duty of care obligations. And at the same time, the bill abandons the e-commerce directive provision of general monitoring. In fact, in specific circumstances, it encourages the use of what they call proactive technology, which essentially is monitoring technology. And the bill institutes what I would call a new regulatory system based on codes of practice. So codes of practice are essentially terms of service negotiated between platforms and the new regulator Ofcom, which then are well, the relationship between the executive, so whether the Secretary of State has to approve them or can guide the regulator. These are issues which are still highly contentious, and we will watch very, very closely how the bill goes now through the reading in Parliament. And there are no safeguards against automated content moderation decisions because IP is not part of the scope of the new bill. So if the UK's new regulatory regime is based on these codes of conduct or codes of practice, which also surfaces in the digital markets unit and in some ways in the European interventions as well, I would argue they deserve much greater attention than they have. So codes of conduct are attractive. They're attractive in that they are flexible. They can be adjusted more quickly. They can be tailored specifically to circumstances, to firms, to business models. But they are also much harder to underpin in a sense of acceptable democratic powers. So the discretion to the regulator to intervene and the delegation of particular powers to the terms and conditions enforced by private firms, this requires much more attention than we have seen up to now. Okay, so I'm aware we need to leave space for the other speakers. So I just point you here to some of the research we have done in this area, and I would welcome approaches to explore these issues further. Thank you.
Thank you, Professor, for your very interesting presentation. I will move quick to the other speaker, Professor Alfonso Contaldo, professore di diritto dell'informazione e comunicazione digitale, Accademia Belle Arti Roma, autore di diverse monografie, numerosi articoli sui temi del diritto dell'informatica giuridica e per esempio sulle piattaforme digitali, cyber security. Professor Contaldo, le do la parola.
Mi sentite?
Sì, perfettamente, grazie.
Grazie a voi. Io non riuscirò a fare il mio intervento in inglese. Mi sentite?
Perfettamente. Allora passiamo all'altro speaker. Anna, can I introduce you as we have technical... Professore, la sentiamo.
Io purtroppo non riuscirò a fare il mio intervento in inglese.
Non fa niente, basta che riduce forse un po' il tempo, purtroppo, perché
sì,
siamo...
lo ridurrò moltissimo.
Grazie mille.
Ho ascoltato con molto interesse gli interventi dei colleghi delle università inglesi e devo dire che la tematica che ho sviluppato in parte è una tematica che riguarda l'intervento del soggetto pubblico nello sviluppare le proprie piattaforme digitali e nella valorizzazione dei propri dati. In realtà non si tiene conto che al di là dell'ecosistema delle piattaforme digitali, che è portato a sussumere dati personali per poi riuscire a trarne una forma di aggregazione che possa essere esplicitata in valore aggiunto per le tipologie di aziende del capitalismo digitale, come le ha indicato Smircek, troviamo anche una forma di sviluppo delle piattaforme pubbliche. Le piattaforme pubbliche in realtà sono una normativa che nasce negli Stati Uniti con il Digital Service Act, che nel 2019 fu proposto dall'allora senatrice della California ed ora vicepresidente degli Stati Uniti Kamala Harris. Individuava in particolar modo una serie di incentivi strutturali per gli enti governativi e per gli stati federati che avessero voluto dotarsi di piattaforme digitali in cui far inserire i dati dei soggetti che ricorrevano ai servizi pubblici, dall'assistenza sociale alle card, all'assistenza sanitaria per i soggetti che ne avevano diritto in base anche all'Obamacare. C'è da dire che le piattaforme digitali in realtà pubbliche sono state erano un'idea già portante del sistema di Obama, ed Obama aveva creato un'unità per la digitalizzazione delle piattaforme già nell'ambito dell'amministrazione della presidenza federale. Soprattutto aveva creato una sorta di dipartimento che cercava di strutturare e finanziare iniziative che potessero in qualche modo incentivare l'uso delle piattaforme pubbliche e l'aggregazione dei dati che potevano esserci nelle piattaforme pubbliche. I dati delle piattaforme pubbliche sono veramente moltissimi in realtà, e a parte quelli di uso per la pubblica sicurezza o per la sicurezza nazionale, che ovviamente non sono rielaborabili e condivisibili, ma sono soltanto rielaborabili in parte e su circuiti separati per poter poi garantire la sicurezza diciamo, l'ordine pubblico di uno Stato. Troviamo sicuramente una serie di dati che invece nella loro riaggregazione e rielaborazione forniscono sicuramente una grande possibilità di ricchezza se estrapolata e poi condivisa con altri soggetti. Pensiamo semplicemente ai dati che possono arrivare all'INPS, ai dati che possono concorrere e poi circolare con quelli degli enti locali, ed è questo alla base di idee che erano già a monte nel Digital Service Act statunitense, cioè combinare dati che erano rilasciati per accedere a servizi come il servizio sanitario previsto dall'Obamacare, oppure servizi particolari che erano indicati per determinate categorie di soggetti, veterani di guerra ed altro, con un'idea di nuova ricchezza da poter magari gestire in una forma di condivisione e magari successivamente anche averla come una forma di ulteriore entrata
abbiamo un problema. Professor Contaldo? Professor Contaldo?
Sì,
per un momento l'abbiamo persa.
Sì.
Prego.
Allora, che cosa succede in questa situazione? In questa situazione succede che, soprattutto per quanto riguarda l'Italia, l'Italia non ha una politica antitrust riguardo alle piattaforme private. Ha iniziato da poco l'autorità garante per la concorrenza e il mercato ad avviare un procedimento nei confronti di Google, che non sia ancora compiutamente definito. Si tratta ora, con il sistema del Piano Nazionale di Ricostruzione e Resilienza, di dar luogo alla digitalizzazione pubblica. Con la digitalizzazione pubblica che si è voluta porre in essere, che cosa sta avvenendo? Sta avvenendo che ci sono delle nuove norme che prevedono l'istituzione di piattaforme pubbliche, e queste piattaforme pubbliche non sono più le piattaforme telematiche per l'incentivazione dei progetti di innovazione, quale quelli della legge del numero 58 del 2019, oppure quelle per il mercato elettronico della pubblica amministrazione, ma sono una realizzazione di una piattaforma digitale nazionale dei dati, un po' sulla scorta di quello che sta avvenendo negli Stati Uniti con il Digital Service Act. E che cosa prevede questa normativa italiana sulla piattaforma digitale nazionale dei dati? Prevede Innanzitutto è una legge nata sulla scorta del Piano Nazionale di ricostruzione e resilienza, ma prevede la realizzazione di una piattaforma che sia finalizzata a favorire la conoscenza e l'utilizzo del patrimonio informativo detenuto per finalità istituzionali dei dati dai soggetti che hanno diritto ad accedervi ai fini della semplificazione degli adempimenti amministrativi dei cittadini e delle imprese. Quindi una piattaforma digitale dei dati nazionali che serve in qualche modo per strutturare una politica di open government. La piattaforma nazionale digitale nazionale dei dati si presenta quindi come una piattaforma di ausilio per una nuova forma di governance pubblica e anche per una nuova.
Professor Contaldo? Sì, se no passo la parola all'altro relatore. Professor Contaldo, l'abbiamo persa, la pregherei, mi dispiace, di concludere anche perché abbiamo un problema di connessione.
Allora,
Grazie.
Quello che voglio dire è semplicemente che la piattaforma, il Digital Service Act statunitense, che riesce a rimodulare l'importanza dei dati in mano alle piattaforme pubbliche, ha rappresentato un modello su cui ricostruire con la digitalizzazione delle amministrazioni pubbliche italiane, col piano nazionale di ricostruzione e resilienza dovuto all'invio dei fondi europei a seguito del Covid, ad una forma di nuova ricchezza del settore pubblico che sia determinata dalla elaborazione dei dati che inviano i cittadini privati e che consenta soprattutto di fare nuovi tipi di aggregazione dei dati attraverso degli algoritmi pubblici. Il problema degli algoritmi pubblici in Italia è dovuto dal fatto che o sono prodotti da aziende completamente di proprietà pubblica, come può essere la Soggei, o se vengono acquisite da aziende private, potrebbero svilire la ricerca e lo sviluppo.
Professor Contaldo, niente, mi dispiace, professore, passo la parola adesso all'altro speaker perché sennò non facciamo in tempo. Professore, se conclude proprio un secondo.
Sì, e quindi ecco che l'importanza della gestione delle piattaforme pubbliche diventa rilevante per costruire un patrimonio informativo pubblico che sia a sua volta utilizzabile per gli incentivi che dovranno essere dati ai privati per l'attività di ripresa e resilienza economica del nostro Paese e quindi rappresentano un altro mondo rispetto alle piattaforme del sistema privato di cui hanno parlato i nostri colleghi e rappresentano sicuramente una risorsa ancora da esplorare.
Interessante relazione a quest'altro elemento che si aggiunge alle precedenti relazioni. Passo la parola to the next speaker, sorry for the time, Anna Drodz, che è la EU Policy Advisor della UK Law Society Brussels Office, works closely with the Law Society of England and Wales, EU Committee, Technology and Law Committee and International Committee. The title of Anna Drodz is Emerging Challenges of Digital Trade, Legal Services and Technology. Please, Anna, the floor is yours.
Thank you very much, and thank you very much for having me. I'm very honored to be here in such a great company. Please let me know. Can you hear me well? Is the connection
Perfectly.
okay?
Thank you very much.
All right. Thank you. I can see that we are almost towards the end of the webinar, so I'm going to try and be brief and kind of talk a bit more in general about how technology has affected services, including legal services, and how this is how we see it in the more of a global ecosystem of regulations, which includes digital trade, but also some national regulations. I think that a lot of discussions on international trade and digital trade and services have been speeded up very much by the recent pandemic, where suddenly a lot of us have been forced to stay indoors, and we continued working using digital means. Now, the pandemic has speeded up a certain long-term trend of moving into more digital provision of services, and there are numerous consequences for this. I mean, today we have discussed how to regulate large online platforms that have emerged over the last decade too. But equally, there are consequences on provision of services and also by lawyers. And technology has exposed some of the challenges, some of the tensions, and some of the problems that lawyers have to grapple with. And those are the areas that keep coming back as the technology progresses and the context in which the services are delivered progresses as well. I don't want to go into details on too much details how legal services are regulated internationally, but I will have to go into a couple of those things just to provide you with a bit of a context of how this problem, how these issues are analyzed and seen. If you look at legal services and how they are regulated internationally, you can look at 4 layers of them. The first one is what legal service is provided, whether this is advice or representation. What is the scope of the service provided, whether this is international law or domestic law. How the service is provided, which is modes of supply and by which means the service is provided. And this is actually an important part when we are talking about technology. And who can provide a service, whether this is an individual or a company. And interestingly, this area also has been impacted, or maybe in the future impacted by the technological development. And the technological development has actually challenged some of the basic notions of regulation, because regulation, especially internationally, the legal notions of regulating trade and services are very much about crossing borders, about physical movement. So a service is delivered in a different country, or a consumer from a different country comes here. A law firm or a company establishes in another country, and a person travels to deliver the service. So there's a very big physical movement element to it. Now, technology actually puts that all into question, because you don't have to travel this much. Of course, for legal profession, face-to-face contact remains very important. But there are services that you can deliver remotely, also in other services. And the question that always emerges in many discussions is, what kind of impact does that have for the work of lawyers, not only in regulation of, first and foremost, on professional obligations of lawyers, but then also how to regulate the provision of services internationally, where the technology has so much increased the scope and reach of the service of an individual. And one thing that the technology has done a lot is to expose the tension between the increasingly borderless nature of some services and very much borderful or territorial nature of regulation. I mean, we regulate predominantly at national level in many services, especially legal. So I think this is the first big area. The technology has very much exposed that tension, and as a result, when we are operating internationally, in any service, including legal, we are dealing with a patchwork of different regulations that have to be taken into account. From the legal services perspective, a big area of interest and of concern that poses a lot of challenges is the one of data. Because data has been, by the production of data and generation of data has been increasing over the past decades. And data is the foundation of some of the services sectors and is very important for a lot of them. What is important here is that the increased use of different intermediaries such as platforms and online cloud providers, etc., and their location all over the world, which is possible, has exposed or has caused the problem or a concern of what is happening to the data. Where is data stored? How is data treated? Who can access it? How safe is it? And for lawyers, this is extremely important because this touches upon the cornerstone of professional obligations and administration of justice, which is the protection of the confidential nature of lawyer-client communications and data, and also the protection of legal professional privilege. With other European bars, we've carried out quite a lot of work looking into these issues and what do lawyers need to know when using these technologies. And there are a couple of very interesting guidance notes on remote working, for example, and what to look out for when you're using those services. As a professional, I'm happy to share that with the organizers so that they can share the links with those of you who are interested. I think that another important area to look at is digital trade in general and how it is formulated in international agreements and how it impacts on the practice of law by lawyers, and what kind of and how is the international provision of legal services regulated, given that it can be provided on such large distances and in many jurisdictions, each of which has a very different notion of what is in the public interest and whether we can allow foreign professionals to deliver services or not, and how we would regulate this. I think this is the key of what I wanted to actually say. I know that it's quite late, so perhaps I'll stop here. And I don't know if there is any time for questions, but if you have any questions, I'm happy to answer them. Thank you.
Thank you, Anna. We really appreciate your presentation and all the points that you touched, also because they are very familiar to us as we are lawyers, all of us. Sorry for the time, but anyway, I would like to thank you, all the guest speakers, outstanding speakers, for all the presentation that were very interesting. And we hope to see you again another time, and maybe in Rome. I don't know if Giuseppe...
Grazie, Sofia.
Thank you.
Grazie. I also want to thank all of you for your presentation today. Much appreciated. Very interesting presentation. We look forward to the next webinar. And of course, we will be delighted to invite you to speak again. So we will keep you informed. But by now, thank you very much. Much appreciated. And we see you soon. Goodbye. Grazie a tutti. Grazie.
Bye.
A tutti.
Grazie.
Ci vediamo presto.
Buonasera.